Supreme Elite Team. Classic session. Yeah. Thomas. Walk in the room like a motion to win. Yeah. We took our L straight on the chin. Yes. Turned into leverage, pressure the gym. Flip every cause, I don't break, I bend. Cap on the stack, that structure and flow. Woo. Draw down the play, watch the balance she wrote. Real game, real games, never just please. Nah. Welcome to the grind, the Supreme Elite. Thomas your teacher, yeah, he your teacher. If this was a sermon, then he'd be your preacher. Sit down the giant, the credit accepted. Called up Jeffrey, you know he respected. Yeah. Said you, we not getting stepped on, all we step through. All switch when the foul won't see the net move. No more dating, got the title that's flex move. Now your next move, make sure it be your best move. Supreme Elite Team, University. Thomas teach the code, that's the key to me. Yeah, he self-taught, but he made it look so easily. Easy, he still up with an attitude like easy, he done make sense. You your best move, nah. Matter of fact, said you should be your next move. Next, self-taught, but he made it look so easily. Easy, he still up with an attitude like easy. They still in hard with the finest chart. On God, don't make a payment, they don't care, they just write it off. Gone, but it's who cause of the contract. That's major hook. Collecting other books, now look, I just made you look. Yeah. They chasing that account, bro. They still gon' sell it. Wow, taking that is law, but it came from Roger Elvick. All these processes, all they doing is really stalling. Yep. Trust law, status, templates, put it in the garbage. Here, Supreme Elite, you're my tomb elite. Let's get it. These gurus thinking they elite, we don't see your receipts. Never just buy this, buy that. Come and take my master class. Please, say you now. We got something that's for your ass. Supreme Elite Team, University. Thomas teach the code. That's the key to me. Yeah, he self-taught, but he made it look so easily. Easy, he still up with an attitude like easy. That makes sense. You the best move. Now, matter of fact, said you should be your next move. Next, self-taught, but he made it look so easily. Easy, he still up with an attitude like easy. In your white head, sweat of the grind. Sign your own name, claim your own time, read every line. I'm the line you see. Class forever over. It's Supreme Elite. Supreme Elite. Supreme Elite Team, University. Thomas teach the code. That's the key to me. Yeah, he self-taught, but he made it look so easily. Easy, he still up with an attitude like easy. Now make sense. You your best move. Now, matter of fact, said you should be your next move. Next, self-taught, but he made it look so easily. Easy, he still up with an attitude like easy. Yeah, y'all know what it is. They call with these packages. Secret accounts like they had in the rack to pursue that BS. Not knowing that theory came from Roger Elvick. It was all a mix. Now look, I see them. Look at them, so desperate, they like flies on. They heard free money without understanding, and they jumped on it. OMG, look at them. Embarrassed they feel for the okie dough. Now they don't wanna admit they got taken to the bank because of their own desperation and greed. Now they wanna hurry up and do another process to cover that embarrassment up. Now I see you. Can't pay your bills, now you wanna create instruments for nothing, bagging it. Thinking this C for the count gon' save them from their reality. Oh no, where the millions at? Where the mansions at? Where the assets at? Nowhere to be found, nowhere in sight. But y'all wanna get mad at me, cause I'm winning. We winning, bet you winning. Yes, we would defend for you from the struggle process. You won't have to tender a check just cause you can't afford a water veil bill. You'll be like me, man, wipe the way and take them back to you. Free and clear. Supreme Elite Team, University.
They studying the source now. Supreme Elite. New Empire talk. Came on reading numbers, they were reading memes. He was reading fire, planning out the dream. Turn every late fee in the case law heat. Judge bang gavel, he don't skip a beat. They like how you flip stress into assets. How you turn a loss in the last check. Thomas took notes, broke codes, then he proved it. Now the classroom global and the language fluid. Thomas is the blueprint. Write that in the sky, let the crew print. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas lay bill to the full camp. New culture empire, watch the flag plan. Supreme elite team university. Turn the credit score into currency. Turn the closed door to a first key. Turn a side job to a legacy. He beat odds, then he beat litigation. Now we teach law like a new translation. From confusion into consultation. From survival into foundation. They log in, lights on in their eyes now. Section this, call that. They reply now. He like, know your rights, then apply now. God, that's the real.
Hold on. Man, the new culture, you don't know what you talking about. You can't guide your clients in court. You can't be on the phone with them while they're in court, giving them advice, advocating for them, going over the script with them, being there in court with them. Man, she got 4 different gurus. 4 different gurus who she went through. All 4 of them couldn't get the job done. She got into a judicial default because the gurus didn't even know the basics of responding to a complaint with your affirmative defenses. You got 4 different gurus that already messed the case up. There ain't nothing you can do at this stage. Nothing. Okay, you got lucky with the first summary judgment trial, and you came through in the clutch for by providing a key piece of evidence for her that she on the trial continue. But now Loan Depot has filed the records. They got the amounts due. They got the witness to testify to the amounts due. They got the balance due of over $400,000. The new culture. There is no way that your client is going to end this meeting without the judgment being for Loan Depot. The decks is already stacked against you. Remember, new culture, your clients are already in judicial default because the gurus, instead of responding with their defenses and their counterclaims, they was filing notices of trespasses in sovereign citizen lingo. So they already fucked the case up for you. You can't come out from under the clutch. This is their second attempt. There's nothing you can do now. They paid you their money for nothing. So what that you got the records that these gurus filed, you had them withdraw. You couldn't get the judicial default erased because remember, they waited 4 months until after they got with you. And then you was the one to realize, oh, nah, y'all never made a legal response. So by the time you got to doing things right, the judge denied the motion to amend and file because you were too late. They should have came with you 4 months earlier. But new culture, you can't stage off another foreclosure attempt. Not 2 times in a row. No. Man, stop lying. You ain't even got the hearing. You pump faking. You ain't got the hearing. Okay, play the hearing then. Play the hearing. If you got the hearing, you got real life in court receipts. Play the hearing then, new culture empire. And that's exactly what I'm about to do. Just give me one moment.
You're rocking with the best.
Oh, and to answer to you, nah, bruh. See, this is the problem. I'm different over here. We do this shit on a professional level over here. I got the receipts. I got the hearing. Yeah, the gurus that she went with online, they got her so far off first base that, hell, I'm just trying to stage off foreclosure for them right now. I get it. These are the hands that I was dealt. But I don't moan. I don't complain. I deal with what's in front of me. Nah, this ain't no document where you just send them a document on their way. I'm going to be in court with you on the phone. Just make sure you mute the court's Zoom when I'm talking to you. I'm going to be right there with you. I'm going to be with you. We in this together. We are locked in at the hip because I'm treating your home like it was my home. But nah, don't trip. I'm not going to sit here and say that the Loan Depot got the judgment or they got to try again for the third time. I'm not going to tell you what happened. I'm not going to tell you. All I got to tell you is watch it for yourself. And it's coming soon. Share the live stream.
They studying the source now. Supreme Elite. New Empire talk. Came on reading numbers. They were reading memes. He was reading filings. Planning out the dream. Turn every late fee in the case law heat. Judge bang gavel. He don't skip a beat. They like how you flip stress in the assets. How you turn the loss in the last check. Thomas took notes, broke codes, then he proved it. Now the classroom global and the language fluid. Thomas is the blueprint. Write that in the sky, let the crew print. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas is the blueprint. Supreme Elite team, that's the school stamp. From the first lay bill to the full camp. New culture empire, watch the flag plan. Supreme Elite Team University. Turn the credit score into currency. Turn the closed door to a first key. Turn a side job to a legacy. He beat odds, then he beat litigation. Now we teach law like a new translation. From confusion into consultation. From survival into foundation. They log in, lights on in their eyes now. Section this, call that. They reply now. He like, know your rights, then apply now. God, that's the real drip. Let it dry now. Thomas is the blueprint. Write that in the sky, let the crew print. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas is the blueprint. Supreme Elite team, that's the school stamp. Wave it from the first lay bill.
You're rocking with the best. You're rocking with the best. You're rocking with the best.
Yeah. Let's come on and get up off it. Y'all already know what time it is. Y'all already know what time it is. And we gonna know what time it is if we understand what time that it's in. Because I'm gonna tell you this. Give me 1 second. I know it's the thing that's still on the field. I know. Give me 1 second. Give me 1 second. Because we about to get it. We about to get it. We about to make it jump. Now, we about to make it jump. So what I have is a client, and y'all, the backdrop of it, if I can, give me 1 second. Going through a little technical difficulties, but give me 1 second. 1 second. We are double streaming from the New Culture Empire and of course, TikTok. Now, as I'm trying to get this thing off the screen, please, as I'm trying to do it, I will try to do it. And my client got with 4 different gurus. My clients got with 4 different gurus. And they themselves found them in what we call a judicial default. Now, why were they in a judicial default? Because instead of responding to the complaint, the gurus had them respond with notices and sovereign citizen rhetoric, which actually got them into judicial default. By the time they came to me, they was already in a judicial default. And the clients, I mean, not clients, but Loan Depot had already moved for summary judgment. 1 second, YouTube. I got to exit out of this, come back in order for me to get out of this. 1 second. I think I'm going to have to exit this because it won't take it off that screen. Now, we had a hearing March 12th. My client, now, they went through 4 different gurus. One guru filed some notice of trespass against the estate. Another guru told her to do bankruptcy. Another guru was talking about taxes. Another guru was talking about the judge's oath of office and bond and the judge's jurisdiction to hear the case. Now, when these social media gurus online talks about mortgages, I know 98% of them are full of sugar, honey, iced tea. Even the ones who comes on the panels and lies about their mortgage wins.
You're rocking with the best.
I know. But look at the situation that I was placed in. 4 gurus, over 60 documents filed that I immediately instructed them to withdraw from the record. Not only that, they had a judicial default because the so-called intelligent gurus didn't even have her respond to the complaint with her affirmative defenses. So she was placed in judicial default. 4 months later, after she got with me, that's when we actually filed a response because court rules of procedure. I said, yo, you never responded. Even though they was going back and forth with you, a response has to be under the Florida court rules of procedure. So I try to correct the guru's mistakes by filing a motion to set aside the default judgment and amend and leave to file the amended response to the complaint. The judge denied it at the May 21st hearing, but we had a summary judgment trial on the 12th. Now, I could sit here and tell you, oh, this happened, they lost, it's all the guru's fault. But I thought it would be better for everyone that's listening. I thought it would be better if you just hear I'm not saying they lost. Only you will be the judge of that. So without further ado, let's just see how it plays out when the new coach of Empire gets into the picture, regardless of the procedural posture of the case. Let's just see how it goes.
I'm beginning to agree with the defense that there's some confusion.
Now, has this experience so far been better than the ones that you had from the past with these gurus?
Yeah, it's like you don't even understand.
Ho. Let's go over the start of the video again. LoanDepotLLC.com is the plaintiff. My clients are the defendants. They're not the plaintiffs in this case. They're the defendants. This is Loan Depot's second attempt to get a foreclosure judgment. The judge declined to rule in foreclosure judgment in their favor at the March 12th hearing based on technical issues that we raised. Now that the judge denied the motion to amend the complaint and set aside the default, now we're at the trial, summary judgment trial. This is the day where she loses her home or they send it back in front of the new judge. But this is a big deal here. She could lose her home at this hearing. So let's just start from the beginning again.
I'm beginning to agree with the defense that there's some confusion.
Now, has this experience so far been better than the ones that you had from the past with these gurus?
Yes, like you don't even understand. It's like another world. Because like I said, the fact that we even sit here and hash out like what went down, what the game plan is, or afterwards, like talk about, okay, this is what could have been done, this is what could have done, we could have done better, or this is where it could go, I've never had that with someone. No, they always just throw paperwork at me, like just figure it out, just read it, and that's it. And then, like you said, because then when it comes to court, it's not always going to go by that little scripture or by those claims that you're bringing up. It could go either way. Just like how we started asking them details about their claims, they're going to start asking us details about our claims. And the thing is, when these gurus just throw you a document, you don't know the details about it.
This is from her. This is her experience. 4 gurus. And all 4 gurus did more to accelerate her losing her home than to even help keep it. This is her words. I don't lie. These are her words. So you social media gurus that's talking, these are what your clients are really saying when they talk to me. This ain't nothing new. There you go. There you go.
You're rocking with the best.
And by the way, I know there's hate watchers. I know people that watch my channel because they're really jealous and hating. I know they watch because they can't stay away. I know they can't stay away. Got so much to say, but they can't stay away. We know.
When people see a court hearing, they usually only see the result. What they don't see is the preparation. What they don't see are the hours spent reviewing motions, studying affidavits, breaking down business records, and preparing a client for what they're actually going to face inside that courtroom. Thomas' client had already been down this road before. She had followed multiple online gurus, multiple theories, and multiple approaches that left her unprepared when it mattered most. This time was different for her second summary judgment hearing against Loan Depot. She wasn't walking into court guessing. She wasn't relying on internet slogans or recycled talking points. She was prepared. While she appeared before the court through Zoom, Thomas was right there assisting her over the phone, helping her stay focused, organized, and confident throughout the proceeding. The goal was never to create a script. The goal was to help her understand the issues, communicate effectively, and respond with confidence. And she did exactly that. Loan Depot did not obtain the foreclosure judgment they were seeking. More importantly, Thomas' client walked away knowing she could stand up for herself, understand the litigation process, and actively participate in her own defense. That's what Set You Litigation knowledge is about. Not empty promises. Not magic paperwork. Not internet mythology. Preparation, strategy, knowledge, support. Because when clients understand what's happening in their case, they become far more effective advocates for themselves. And that's exactly what happened here. Real people, real cases, real preparation, real results.
You're rocking with the best.
Also, you had a chance to go over the figures with the witness.
Share the live, share the live. YouTube, share the live. Facebook, share the live. TikTok, share the live with your mortgage gurus. We ain't talking about documents. We talk about in court, not just motions and pleadings. We talk about in court arguments now. Everything that she's about to do is part of me preparing her for this trial. Yes, we met behind the scenes. We went over the game plan. We went over multiple scenarios, and she knew that at any given moment, we're going to have to throw the script to the side and pivot and go where the case is going. In court, you got to pivot on the fly. And this is her I think her second or third hearing. And after 3 months of her being with me, just watch the difference in her tone now, because I train my clients and the ones who take it serious, where once you're done with me, you will never be fooled again. You will always know how to defend yourself. You will never have to rely on anyone else again. Let's get to it.
Yes, Your Honor, and she did testify correctly as to the judgment figures. The supplemental schedule that was filed with the court on June 4th shows the amount due and owing. I did state, Your Honor, that it's inclusive of the attorney fees and cost affidavits that were filed with the court. That gets to the total of $432,694.06.
And yes, TikTok, shout out, hey, share the live stream, tap the screen. YouTube, I'm not expecting the numbers to be high, because once again, we have real life results. I told you, y'all, people envy your understanding. They envy your knowledge. They envy what they don't have. They envy the receipts that they don't have. This space is filled with 98% haters. They don't want to see other people winning. They only want to see them winning and other people paying for them. A person that got their house taken from a social media guru, why would they want to watch this to only realize, damn, they went down the wrong hole? They don't want to see this. They don't want to receive results. They want people to tell them what they want to hear. This is why I love doing it.
62 cents.
Okay, just because we're on Zoom and there's confusion because we're putting numbers around, can you screenshot your judgment and have the witness go through the figures?
Yes. Give me 1 second.
They got the figures. They got the supplemental documents. They got the witness there. Oh, they got it all. This should be a slam dunk case, right? Well, let's run it.
And then, are the able to see the screen?
We're looking now.
Yeah.
Okay.
Okay.
Attorney's fee,
So-
16,000.
If the witness can go through based on your review of the records that are maintained in the ordinary course of business and explain all these numbers and how they're arrived at, the defense is questioning.
Okay, so we have a principal amount of $316,690.47.
That was left on the mortgage, correct? That was the outstanding balance on the mortgage?
Correct.
All right. That was
Interest,
time of default?
yes.
All right.
Which,
And
Your
then-
Honor, the final judgment just show the interest dating back to April 1, and the witnesses testified to the default date of May 1, 2023, just so they're.
Now, right there, they got the witness on the screen. They got the lawyer on the screen. That's the lawyer at the top, YouTube. That's the lawyer in the top right. You got the judge in the middle. You got my client right there in the blue. You got the witness for loan. They got the documents. They got everything. Name what guru that can fight through that for their client. I'm on the phone. You may hear me snippets in the background. I am on the phone with her during this hearing, instructing her on what to do, what to say, and giving her a pathway where she can, bam, take off from there. I'm telling you, you won't find shit like this online. You won't find another hearing like this. Let's run it.
There's clarity on that.
Okay. Run that by me again.
So it's showing the interest on the note and mortgage from April 1, because we're entitled.
If you're just coming in, this is my client's hearing. This is a second attempt at a summary judgment trial, foreclosure. They're trying to take her home and displace her husband, and her family. My job is to not assist her and them not taking her home today. We're just talking about this trial, this hearing, June 12th. This is my job. They paid me to help them not get their home taken.
To interest 30 days prior. The default date is May 1, 2023. I just wanted to make that clear in this proposed final judgment.
All right, and the interest rate, the interest goes then till today, June 11th. So that's $61,956.15 in interest that's outstanding. All right, go ahead, counsel, if you want to go through the numbers and just kind of have your witness explain them as you go along.
You see how the judge is to say, just go through the numbers and explain it for the defendants. Go through the numbers. But what they don't realize is we had a game plan to attack the very foundation of the documents that they are trying to establish. It uses evidence to establish the amount due, because that's one of the jurisdictional requirements of a foreclosure. Standing, possession, or rights of a holder who is entitled to enforce, and the correct amounts due. We made it our point, our strategy was to attack all the numbers. And we was going over the game plan. We was like, hold on, something ain't right here with these numbers. But in the other case, the judge just allows it. A lot of times the judge would just allow it. They got the witness there. Our game plan is we're going to attack the numbers. I'm a numbers guy. I deal with accounting. I audit balance sheets. These numbers ain't right. So let's run it.
What's the pro rata?
Take notes. Write that shit down.
Yes,
that's me in the background. Take notes. Write that shit down. Because you know what I got? I got my pen and my pad right there listening to everything.
Can you explain that? Go ahead. Sorry.
Yeah, it's for mortgage insurance.
Okay. Does that mean that the lender had to pay the insurance?
Yes, ma'am.
All right. Is that what we're referring to as corporate advances, or is that something else?
The corporate advances, that was another part of our strategy to attack. See, with the corporate advances, they're going to try to throw insurance and this. It's not what it means. But since she's behind the 8 ball, we can't push the envelope right there because the lawyer is going to pivot to, well, anyways, Your Honor, they're still in default. So I have to tote the line. Now, if we get past this hearing, now I get on the offensive.
The defense mentioned something about corporate advances, which generally my understanding is that would be more where you're paying for insurances or taxes.
Yes, so as you can see, Your Honor, then the entry, title search and expensive are the costs that the firm expended for this case, but then you go into flood insurance disbursements, the tax disbursements,
paying for insurances or taxes.
Okay, you're going to hear me in the background.
Yes, so as you can see, Your Honor, then the entry, title search and expensive are the costs that the firm expended for this case, but then you go into flood insurance disbursements, the tax disbursements, hazard insurance disbursements. Those all cumulatively are the corporate advances and escrow advances for the subject loan. And so the proposed final judgment breaks down these line items.
Okay, and just, I don't know if the defense are still with us.
Yes, I'm here, and I want to add
there you are.
that
Okay,
in your exhibit, because I see conflict already. In your exhibit 5.
Look at her. Look at her.
Rocking with the best.
Look at her. Look at her.
You're rocking with the best.
You hear her? See, I put that dog in her. Let's go. See, already, this is part of the strategy.
Of the witnesses and exhibit list that you guys filed recently. The corporate advance is $16,955.90. I did the math already. These numbers are not matching up.
You hear that silence? You hear that silence? You hear that silence? You hear that silence?
So what would be, if you're saying that that's the attorney fee, so what is that $16,955.90? if you already had your attorney fees over here on this document that you're showing me.
I'm not sure which part of the record she.
Gotcha, bitch.
It's in your exhibit list.
You know what page of the exhibit list?
The
Gotcha,
last
bitch.
one, page 33. Exhibit 5.
Here's Exhibit 5, which is the judgment figures.
Look, see that silence? You see that silence? Shout out to Freedom. You see that silence? See that silence? That's not the silence from the judge just being like, man, I want to hear this sovereign citizen stuff. That silence is, damn, I really have to explain this. No, I have real clients in real life situations. Not no online. I'm just kicking smoke up your ass. Nah, I do this shit in real life. Silence. Look at the silence. That's me in the background.
And then while we're adding to that too, another thing that I wanted to mention is that all the other documents have the header Loan Depot, but this one doesn't. And also the total amount due is redacted. Why? I believe earlier, because I'm taking notes here, let me see.
Oh, look at her, boy. Get my clients together.
You're rocking with the best.
Oh, I gets them together.
That the witness already testified to a specific amount that wasn't even the amount that's reflected on that exhibit.
Wow.
And then, crap, where is it?
We need to do one thing at a time because we don't have the exhibit that you're referring to in front of me. So are we looking at the witness and exhibit list that was filed on 5/13? Counsel?
No, Your Honor, this is the supplemental Exhibit 5 of the judgment figures that was filed on June 4th.
They supplemented 3 different times. Every time we attack it, they supplement. We attacked it the last time. This is the new supplement. This is the supplement document from June 4th. And this is the games that they're going to do. They're going to keep coming. They're going to keep trying. She's in default right now, so there's a prejudice. The judge is looking for a reason right now to go ahead and say, this is sufficient. I'm going to grant the judgment. I know how these judges think. So our job right now is to keep hammering on the numbers, keep attacking the numbers to the point where the judge has to just agree with us. I mean, she's going to have to if we're doing things effectively.
Okay.
It was a supplement to update the judgment figures and the breakdown of those figures more succinctly. So it was filed as a supplemental exhibit on June 4th.
Hey, y'all, shout out to the gifts. Shout out to the gifts, y'all. Shout out to the gifts. Shout out. Let's keep pushing, though.
Okay.
So I'm not sure if she's reading off of this exhibit or the previously filed exhibit from 5/13.
So, Ms. Douglas, are you referring to the updated exhibit that was filed on June 4th?
I'm checking now.
And while she's checking, counsel, it's showing a payoff of 422,516.
422,516. The first amounts that they say was due when they filed the foreclosure complaint was 417, about 656 or something like that. So it goes from 417 to 422. Okay, explain the 5,000 difference. Explain those numbers. Because remember, we attack everything that they do from the initial complaint. And if they keep changing it, we're going to continue to tie it back to the initial complaint. You are getting a class within itself right now.
86.
Yeah, they did.
Gotcha, bitch.
So how do we get the extra roughly 10,000 on that?
So like they're really.
There you go. You see that with the judge? See? That's part of the strategy to have the judge start questioning. Oh, this gets good.
Trying to do the math over here.
This summary does not include the attorney's fees and costs that were expended.
You're rocking with the best.
So you would take that payoff number and then add
I don't know why it recorded like that. I don't know why I did that, but just push forward. I don't know why it was already lined up. As soon as I save it, it did that BS. Just push forward, y'all.
your affidavit of attorney fees and cost.
Correct.
You're rocking with the best.
That's me in the background talking to her.
Okay, I'm reviewing it. I just pulled it up. Okay, so you're saying that the 4,666 and 20 cents were added? Because then that still doesn't even add up.
That's exactly what I told her. And she's doing the math too. I told her, write down the numbers. I said, yo, it don't add up. Tell them it don't add up. It still don't add up. We got to stay right there. Her home is on the goddamn line here. We got to stay right there. We done abandoned the script at this stage because we already found a discrepancy. And she didn't get it on recording. But the reason why we got here is they passed this case. They passed the case because as they was going over the numbers and I started doing the math, I did start to look at the numbers like, hold on. And the court reporter blurted out, I got a different number. And that's what started the judge's further inquiry. See, at the beginning, we don't have that because she didn't record it at the time. At the beginning, the judge was just allowing all that shit to go through. But as soon as the court reporter said, hold on, I got a different number. Because the court reporter got to get the right number right. This is why the judge is now doing more inquiry. If the court reporter did not do that, it would have been even more difficult. But now that we're on the record and the court reporter did that, the court reporter is basically seeing the same things that we're seeing. But she was so inclined to believe Loan Depot in the beginning, but now we got the court reporter agreeing with us. Nah, I got a different number. That's not on recorded. That's the only reason why we're here right now. I ain't gonna lie to you. I keep this shit 100.
I'm tending to agree. I'm tending to agree. I'm tending to agree.
On June 4th.
Okay.
It was a supplement to update the judgment figures and the breakdown of those figures more succinctly. So it was filed as a supplemental exhibit on June 4th.
Your third one.
Okay.
So I'm not sure if she's reading off of this exhibit or the previously filed exhibit from 513.
Lady, it don't even matter.
So, are you referring to the updated exhibit that was filed on June 4th?
I'm checking now.
And while she's checking, counsel, it's showing a payoff of $422,516.86.
Yeah, they did.
Gotcha, bitch.
So,
June 4th.
how do we get the extra roughly 10,000 on that?
So like they're really trying to do the math over here.
This summary does not include the attorney's fees and costs that were expended.
You're rocking with the best.
So you would take that payoff number and then add your affidavit of attorney fees and cost.
Correct.
That wasn't a confident correct.
You're rocking with the best.
Look at the silence.
Okay, I'm reviewing it. I just pulled it up. Okay, so you're saying that the 4,666 and 20 cents were added? Because then that still doesn't even add up.
There you go. There you go.
I'm tending to agree.
There you go. There you go. There you go. I'm tending to agree. I'm tending to agree. You think I don't know how to attack business records? Come on, they playing with the wrong one.
I'm tending to agree. I'm tending to agree.
There's no way for me to guarantee. Okay, I'm reviewing it. I just pulled it up. There's no way for me to guarantee that this came from Home Depot. I mean, and how can I verify that it's firsthand knowledge?
Gotcha, bitch.
Okay, well, the heading is basically part of the establishes the.
Judge, get out the way. Stop answering for them. Judge, get out the way. I'm laying a trap for them. Stop coming to their defense. Get out the way, Judge, please. Get out the way. Get out the way, please, Judge. God damn.
Lawsuit, the parties to the lawsuit, the exhibits wouldn't necessarily have that header on it.
I'm not talking about that.
You'd have to look at where it
You see that right there? YouTube. You see that right there? You see I say Loan Depot at the top?
indicates the name of the bar.
TikTok, it say Loan Depot at the top. Now look, the second document that's on the screen on YouTube, if you look at it, it don't say Loan Depot nowhere.
Co-bar, addresses, those type of things to determine, if it's the correct people. But counsel, I'm a little confused too now because these numbers don't add up.
Let's run it.
You're rocking with the best.
All those sidewind social media arguments, all the sidewind arguments they gonna make, all this, oh, do this, or do this, or do this, trespass, notice of trespass against the estate. Nah, we going straight court rules and procedure. Practical statutory law. The same thing these sovereigns tell you they not governed by. I'm going by the same laws that y'all say y'all not governed by. Fuck it, let's run it then. Let's run it. Let's run it.
The lawsuit, the exhibits wouldn't necessarily have that header on it. You'd have to look at where it indicates the name of the bar, co-bar, addresses, those type of things to determine, if it's the correct people. But counsel, I'm a little confused too now because these numbers don't add up.
Let's run it.
Counsel, I'm a little confused too now because these numbers don't add up.
Let's run it. Let's run it.
Any of my monthly
$534.
I got you to my ear, so whatever you want me to say, I can say it. I got you low too.
She's talking to me. She's talking to me. We're communicating back and forth. Remember, I'm not a licensed attorney. I'm starting to question whether I should go take the bar. Because my in-trial arguments is I am a dog in court litigation.
I'm trying to.
I ain't talking about motions, typing shit up. I'm talking about in-court arguments. I know how to object. I know the rules about reject. I know about business records, laying the foundation. I know about highly complex securitized trade. Listen, I self-taught myself over 10,000 hours over years. You're not dealing with a rookie over here. No, we had to sway the judge in our direction. The judge was agreeing with everything in the beginning. I just don't have that recorded. She started recording when we came back after they passed the matter. Then this is when we came back.
Get you close enough to hear it, but sometimes you get loud and I think they hear it.
Yeah, she's talking to me.
So for the $24,870.60.
And what she's going to do is just read what's on the screen. What she's reading, YouTube, TikTok, it's already what's on the screen. She's not breaking down how they came to the numbers. She's not breaking down whether part of my client's mortgage payments contributed to the insurance. She's not breaking down how they derive for those numbers because they can't. Because if they actually start to break them down, now it's opening the door to the what? Corporate finance lens. Now we're getting to the financial statements of position. Now we're getting into the bread and butter of Supreme Elite Team University. Now they don't want to explain the numbers because remember when I said they got multiple different accounts and they got the reserve account here. They got this account here. They got that account there. Now it's going to force them into the conversation where, well, all these payments that they were making, it wasn't going towards the true use and forbearance of money, which is supported in case law, is supported by the IRS. The IRS even knows your balance on your contracts. They even know that's BS. They don't look at that number. They look at the applicable federal rate. Like, we getting deep into the corporate finance, and this is why they are vague when they explain in any foreclosure, when they bring a witness in to explain the numbers, is going to be some vague, just reading what's already there in the exhibits. They're not going to break it down. They're not going to explain how they got the numbers, how they calculated the numbers, how they derived the numbers, because now we're going to get to the CECL. Then we get to the ACL, which requires an adjustment to the... Man, stop playing with me. Y'all not fucking with no rookie over here. Come on. Let's go.
You're rocking with the best.
That goddamn SEC, boy, y'all don't know who I'm connected with.
5 cents. Payment into escrow. Another $59.22.63.
You notice how she's not going to explain how they got to the numbers. She's just going to, this the numbers and this what it's for. That's it. We attack that.
To escrow. Then we have the deduction of the POI payment, $9,759.72.
To provide the breakdown of that.
Walking right into our trap. Look at the silence. Look at the silence before she responds. Look at her silence. Look how silent. Crickets. Look how silent they are. Come on. You got the numbers?
I got you to my ear, so whatever you want me to say, I can say it. I got you low too.
We know.
I'm trying to get you close enough to hear it, but sometimes you get loud. I think they
Hell
hear.
yeah, I get loud. Hell yeah. I'm passionate about
So for the $24,870.65 payment into escrow.
Explain the escrow. Explain how you got to those numbers. Explain how you got to those numbers. You got firsthand knowledge, right? Explain the numbers. Nope, they never can. They can't explain the numbers because everything is tied into the secondary market. This is what these online gurus don't get. It's tied into multiple transactions that has nothing to do with you. That's why.
Another $59.22.63.
Is she explaining? Is she explaining how she got to the numbers? No, they can't. But we know why she can't explain it. They don't want to expose themselves.
Went into escrow. Then we have the deduction of the POI payment, $9,759.72.
What? Explain the PR payments. Explain why was it deducted. Explain how you derived to those numbers. Once again, they can't.
Then the tax payment, $11,534.31.
What is she doing? Y'all, what is she doing right now but just reading what we can see on the screen? What my clients can see on the screen. Is she breaking it down? No, they never can. It's going to expose them to the secondary market. Yo, I'm telling you, when I say I've learned from the best, I learned from the best.
Then we have the flood insurance payment, $62.15.
Explain that $62.15. You can't.
And then we have the insurance payment of $42.50.35. That totals the escrow.
So what explanation? We all see that, y'all. Everything that she's saying, it's already on the screen. Explain how you got to the numbers. We are attacking the numbers. We're not attacking what the things were paid for. She's explaining what it went to. We're attacking the numbers themselves, and they can't justify the numbers. I told you, you got to be able to pivot in court.
For $24,966. $24,966.10.
Did any of
Now, this is the question I told her to pose.
these fees come from any of my monthly mortgage payments? Or did you take out insurance into this?
Well, I believe the terms of
God
Obtain the
damn it!
foreclosure judgment
Oh,
they were
shit.
seeking. More important.
Hold on, George.
Just trying to double.
Hold on.
Escrow for $24,966.
All right.
$24,966.10.
Okay, cool. Now I told her to ask this question.
Did any of these fees come from any of my monthly mortgage payments?
Did I pause? You hear that pause? You hear that pause? Because I already know about their secondary market. I know that they don't want to go there. I know why those numbers are there. They don't want to go there.
Or did you take out insurance into this?
Remember, any trial lawyer, you never ask a question that you don't already know the answer to. That question was asked to tie them up. But watch what the judge does.
Well, I believe the terms of the mortgage.
God damn it, get out the way, Judge. Why are you answering for them? Get out the way. Get out of the way, Judge. We're not questioning you. Stop saving them. Get out the way. God damn, get out their way.
Mortgage require that the borrowers maintain.
Get out the way, Judge. You're saving her right now. She don't want to answer. That was a question for the attorney. I know why I'm asking a question. She don't even know the answer to it. That's why I'm asking it. God, you keep saving them.
Insurance on the properties and that you pay the taxes. And I believe your mortgage probably said that if you don't, that the lender can put what we call forced insurance. Basically, they buy the insurance to protect their property.
I believe what the mortgage says. Your Honor, you don't know. Stop. Come on. You're letting Loan Depot off the hook. I wanted the attorney to answer that shit, not you, Your Honor. And you're not even, Your Honor, get out of here.
Which is generally more expensive than if you took it out, but it's only because you're in default that they have to take it out.
Of course, default.
So that wouldn't be in your records because you didn't pay
what,
it. That's why the bank had to pay it.
Okay. Thank you, Your Honor. I'm glad you said that because that came with my next question.
Is there any evidence of the insurance being paid in? That they took out the insurance.
There you go. Since you said that, Your Honor.
You're rocking with the best.
Now answer that question, Your Honor. Since you want to answer questions for them, let's see you answer that. Once again, more silence. Once again, more silence after the question is posed. Once again, more silence.
Okay.
There's no requirement.
You heard what she said? Okay, counsel. You see how the judge want to get out the way now? Because she can't confirm that. So what did she do? All right, counsel, you should have did that from the beginning. Now watch what the lawyer says.
To establish insurance being taken out, only that the payments have been expended, which is what the payment history that's been admitted as Plaintiff's Exhibit 4.
So she said there's no requirements to establish that the insurance has been paid out, but only that the payments were dispersed or what. Do you hear this BS, this googly gop that she's saying? Look.
Being paid in. That they took out the insurance.
She's going to say counsel?
Okay.
There's no requirement to establish insurance being taken out, only that the payments have been expended, which is what the payment history that's been admitted as Plaintiff's Exhibit 4.
So the payments have been, they don't have to show that they actually took out insurance, but only that the payments has been expended. If payments are going to be expended, that means premiums were being paid. You pay premiums on insurance. Insurance is insurance. You make your monthly or every 6 months or whatever your premiums. Then in the event of something, you get paid out. So the question was, did Loan Depot make the premium payments on the insurance with a portion of their monthly payments? And the lawyer did not say no. They say there's no requirement. Remember, they was going to try to use rules of procedure. There was no requirements to establish that. But that's a direct question. It's either yes or no. And what did she do? She sidestepped it because I already know the answer to the question.
have been entered into evidence.
No.
I'm just trying to double check here on the attorney fees, Your Honor.
No, why are you double checking? You done filed 3 amendments. You already said the second documents updated the attorney fees. Why are you double checking now? Don't double check. You had your ducks in a row. And more silence. A common theme, the long silence. The long silence. Silence.
And then I want to know, how did our monthly payments not go towards the monthly premiums?
And that's what I told her to ask again. How did it not go towards it? Because she never said it didn't. So how did it not go towards it?
Again, like, I understand what you're showing me here, but there's not really that much details.
That's us communicating. And more silence. More silence. I'm not making nothing up. This is for my client's hearing. More silence. Look, long silence. Long silence. Look, more silence.
Counsel, I think this is becoming too complicated.
Of course it is now. Yes, of course it is.
You're rocking with the best.
Of course it's becoming more too complicated.
You're rocking with the best.
Of course it's becoming too complicated when you start asking the right questions and attacking. Of course it is. Of course it is.
To be doing this on Zoom.
Oh, nah, you scheduled it on Zoom, Your Honor. Nah, let's continue.
Without having the records here, I think it needs to be done in person.
Of course.
Okay. Let's go ahead and just refer it back to the assigned judge so it can be done in person.
Of course. Of course.
You're rocking with the best.
Of course. Of course. You had. Now you going for round 3 to try to take that home? Ever since I came in the picture, it's becoming more difficult for you, hasn't it, Loan Depot? Ever since I got in the picture, it's becoming a little bit more difficult, hasn't it? I'm going to throw it in you finance corporation side, ain't I? It's becoming way more difficult now, ain't it? You had a slam dunk with the first 4 gurus. Now the arguments change. The postures change. Her arguments in court changed. Now it's becoming Now it's becoming complicated. No, it wasn't complicated in the beginning when you was agreeing with them, Judge. Why is it complicated now? Huh? Why is it complicated now? What's so complicated about it? Explain the numbers.
And then the defendants can be present and actually look at the documents.
And they're going to be prepared for round 3. They're going to be prepared for round 3.
As they're tendered into evidence.
2 times they tried, 2 times they failed.
So we'll basically continue the trial, be reset in front of the assigned judge. Is that something case management will facilitate? Okay, so the case managers will facilitate that and then send the notice for the new trial date.
Of course.
Okay, thank you, Your Honor.
All right, very good.
Thank you, Your Honor. Have a good day.
Thank you, Your Honor.
You too.
Hold on. So they had, of course, the lawyer for Loan Depot. They had 2 witnesses. They had the accountant and the loan person that deals with that stuff. You had 2 witnesses, and you had a licensed attorney, and you had 2 witnesses that works for Loan Depot or associated with them, and a licensed attorney. And on the other side is my client with 3 months of preparation. That's it. Only 90 days. But the X factor is she had the new culture empire in her corner. Let's run it.
You're rocking with the best.
That makes a difference. Now let's run it. Why do I keep doing that? Let's run it.
The escrow.
I want to know, how did
I have a
Judge.
The trial to be reset in front of the assigned judge. Is that something case management will facilitate? Okay, so the case managers will facilitate that and then send the notice for the the new trial date.
Okay, thank you, Your Honor.
All right, very good.
Thank you, Your Honor. Have a good day.
Thank you, Your
You
Honor.
too.
Hey, what's going on, Jeff?
Hey, Lamar.
Hey, yeah, I just called. I had a question for you. So, follow-up call. I think 2 days after the trial. Follow up with my same client. Let's run it. I had a question. To my group members. So I was trying to get them to understand that as far as court rules and court proceedings go, that, you know, from the position of default and the position of plaintiffs are two different things, how the judge court's going to view it. Now, remember yesterday how the judge was so, like, in the beginning, a little prejudicial because, you know, that she allowed the records to get through. You know, she allowed admitted them as evidence and exhibits, right? Now, and that's the problem. When they was moving to admit the evidence into record, the exhibits as evidence, I was texting her to object, but the judge already admitted it before she can actually get to the text and read it. It wasn't 2 seconds, like not 2 seconds, about 30 seconds after she admitted it into the evidence, to the record, is when the numbers started becoming the focal point of the hearing. It wasn't then. I wanted her to object it, because if she would have objected and then we start talking about the numbers, then the judge couldn't admit those records into evidence, allow them to be admitted. And then I would have told her to move for the court to rule on the motion to dismiss, because the evidence are not admitted into record. And you see the end of the proceeding, she wasn't able to admit those records into evidence. But I was texting her to object to it, because that's a legal defense. Remember, object the admission of the evidence. And you see how all these complications started. The judge wouldn't have admitted it. Now they would have to file their own motion to dismiss the case, or we would have moved for our own motion. But since the records were already admitted, she continued it. But the focal point is, she doesn't have to worry about a sale of her home right now. And this is the second attempt that they tried to take her home. If she was with any of these other gurus out here, her home would have been taken at that hearing. And they know this. Remember when she started to change her tone and she was like, yo, I'm starting to believe the defendants, or something to that effect. So with you being in court yesterday, I'm trying to tell people that court is not meant to be 100% fair, and that there's always going to be a presumption, and that you have to prove to the judge and shift the burden back to them. Because, you know, we was in court yesterday, and I mean, from your own, you're understanding it more as we go along, right? I just wanted to make sure.
Yeah, definitely. Okay. Especially with all the things you've been saying too, like saying how like the civil rules and the procedures, how it's not even like about the facts itself. It's just basically the rules. Yeah. And so to add to what you're saying, so I think the judge is already going to have a bias towards the defendant. Yeah. You know, they lay in each other's beds altogether. Yeah. I didn't like how she was defending the paperwork, because we were already, you know, fighting against the business records. Right. And she was already like trying to basically speaking for them and say like, oh, well, we already verified those paperwork. Those people already have affidavits and they're verifiable. They're great. They're good. But when we started asking for details into it, because they're going to leave it, like you said, very vaguely, they're going to agree to it that, you know, like, yeah, they're business records. Boom, that's it. They're accepted. I saw the business records.
That part right there. Does she sound like a person that was dealing with 4 gurus before me? See how I got her litigation up? See how she sees it? 90 days. That's all it takes. 90 days working together with me. That's all it takes. That's all it takes.
Question, how are they business records? And that's when she started realizing, because we're asking more details, then she can't really be agreeing to it.
Right. And you notice it. Right. And you notice it, like she threw them right back under the bus when we asked the question, because we questioned. She said, we was like, explain those corporate advances. Man, I was like, yo, tell them to explain those corporate advances. And then she said, oh, that's more like interest. And, you know, it's typical that if the lenders take out insurance to protect, you know what I'm saying, to protect their
Yeah, she
interest in the
was speaking on their behalf.
Right. And then we countered with, well,
it doesn't add up.
It don't add up still. And I think the question was, well, do you have proof that you actually took out the insurance? I think that was the. Yo, do you think 98% of these gurus is even thinking that far down the road? Hell, do these gurus even have proceedings from their clients in court based off everything you teach and advocate for? No, the only recordings of proceedings are going to be them asking for the judge for the oath of office and establish their jurisdiction over them. You notice how nothing in this hearing had anything to do with you hearing online? All these rhetorics. You notice, do they ever have recordings with their clients in court and then a follow-up call with them? No, they don't. The question we posed to them.
Yes, that's what you had. You told me to ask them that about the insurance because they were saying because the witness had said, which is their I guess their accountant,
right,
saying that that it was FHA. So then that's when you told me to ask them. Okay, so don't we need accounting records for those then to prove that it was used towards it?
Right, and remember
that's when she threw it back to them.
The judge threw it back to them. The judge said, "Oh, the plaintiff, that's a question for you." I said, oh, no, you've been answering for them this whole time. She threw them right back under the bus. She said, oh, shit, yeah, I can't answer that question. And what did she say? Oh, that wouldn't be for your records. That wouldn't be for the purpose of this. That would just be our records. And that's, she was like, oh, so there's nothing on the record that shows that you actually took out insurance then. Oh, my gosh. There you go. See, when we talk about silence over here, it's not the silence where, judge, can you put your oath of office on the record for us? And the judge just remains silent, like, I'm not going down this road with you. The silence over here actually means something. Because the silence over here actually, in the end result, yeah, this is too complicated. We're gonna have to reset this again. Oh my gosh. So what we're gonna do now, listen, they've had two opportunities, yo. Like, they literally have been trying hard. They had two opportunities to get it done. I'm not guaranteeing anything, but we're gonna move for a motion to dismiss, our own motion for summary judgment before the next hearing. Yeah, we're gonna put it on the table because they had two opportunities, and how many chances are they gonna get? And I didn't move for my own motion prematurely. I waited to see their evidence. They want to supplement their evidence. I waited for that. And I said, okay, let me fight. They're going to let them throw all the arsenal at me and at us and let's defend it. If they can't get through this time, then I'm going on the offensive. Court is strategy. They had 3 months. They had 3 months. They had 3 months from the last hearing to get these records in order. And they supplemented the records, and the amounts were still off. My calculator told me, don't put these numbers in again.
Yes. No total. It didn't matter. It didn't matter what total they brought up because they already gave 3 totals. Right. The one that I added supposedly to what they were saying that it was because these are the extra interest, and it came out with a different total than the 3 ones that they offered or that they mentioned.
Does this sound like a woman who's scared about losing her home right now? Do you hear the confidence in her voice? When she first got with me, she was at her wit's end. Like, I went to this guru, filed bankruptcy, I lost money with this guru, this woman told me to do. Does she sound like a woman who's been through 4 gurus already? No. 90 days. That's all it took to hit her with that antidote. I couldn't take off the 16,000 because they couldn't explain it. They couldn't explain the numbers.
16,000 didn't match because that form that I told you that I recorded that it looks like they typed up said 60,000. And the exhibit was like 16,955, and then in that document that I showed you the recording of, it said 60,400. It was off by a few hundreds. So it was still the same 16,000. So I don't know what they're adding.
But you see where she's looking at now? She's attacking this like a real litigator now. Just 90 days. See, you see the confidence in her voice? You see what happens over here? Magic is made. when we're working together, when me and the clients are working together and we're on the same page. This doesn't sound like a woman that's stressing over losing her home right now. No. Here's one of the things for them to collect on the amount or foreclose or whatever. The amounts due has to be accurate. So what are you going to do for the third hearing? Come up with brand new numbers? We're not allowing it. No, we're not going to.
Still argue even then too.
Right. Because the original numbers that were filed is what we were going by. The full 17. So what you're going to file this upcoming week, we're going to file a motion to dismiss plaintiff's complaint, and or in the alternative, at least set aside the default judgment again. You get what I'm saying? At least they should entertain that.
Pick one.
Yeah, pick one. At least entertain that again. They had 2 bites at the apple. At least set that aside, because now it's getting to the, like, come on now. How many chances do y'all get? Y'all don't get these many chances for real. You had 2 opportunities and you couldn't get the job done.
The proceeding. The goal.
So which one's the truth?
Summary judgment before the next hearing. Yeah, we're gonna put it on the table because they had 2 opportunities. And how many chances are they going to get? They had 3 months. They had 3 months. They had 3 months from the last hearing to get these records in order. And they supplemented the records, and the amounts were still off. My calculator told me, don't put these numbers in again.
Yes. No
3 months from the collect on the amount or foreclose or whatever. The amounts due has to be accurate. So what are you going to do for the third hearing? Come up with brand new numbers? We're not allowing it. No, we're not going to.
Still argue even then too.
Right, because the original numbers that were filed is what we were going by. The full 17. So what you're going to file this upcoming week, we're going to file a motion to dismiss plaintiff's complaint, and or in the alternative, at least set aside the default judgment again. You get what I'm saying? At least they should entertain that.
Pick one.
Yeah, pick one. At least entertain that again. They had 2 bites at the apple. At least set that aside, because now it's getting to the, like, come on now. How many chances do y'all get? Y'all don't get these many chances for real. You had 2 opportunities and you couldn't get the job done.
You're rocking with the best.
So,
you know, I didn't like too that the witness who was testified said like 3 different numbers, and she was still like held up like she was in honor or speaking like under oath and all that.
Right.
So which one's the truth?
And your cross. I'm glad that you put those things on the record, those questions, those set of questions of firsthand knowledge. And I truly believe this is one of the times where the judge was kind of being a little bit too partial, because some of those questions were distinct. And as soon as we started getting them in deep water with the questions, what did I tell you? These lawyers, they're always going to object when the questions are starting to get too personal. That was the first half of the hearing, what we heard was the second half. Yo, the dude was fumbling. We asked this 5 set of questions in the proposed response. So I gave her the questions to ask to lead off with. And I said, the answer should be no. But if he says yes, ask this. If he says yes to the second one, ask this. The first 5 questions we asked was no. Well, no, I wasn't there. No, I didn't execute. No. When we got to the 6th one, the lawyer, Your Honor, we're going to object this. And then when we got back to the line of questioning, I told her, okay, go to page 2, ask these questions. The lawyer objected and said, well, Your Honor, they're still in default. That is, it's the sinking ship, and I got to do something. See, I wish you would have recorded the first half. I put the whole line of cross-examination together for her. I did. I said, listen, read. We ain't got time for you to read these questions. Ask these questions. And I'm sitting there with my pen and paper, and I'm marking his answers. And if you went to yes, okay, ask the second one. So as they started proceeding down, I said, go straight to the business record section. Go straight there now. I had 3 more pages in front of that. But in court, how the proceedings going, you're going to have to pivot. So we had to throw away the script and go straight to this page right here. And then it went from going straight to this page right here to pull your calculators out now. The hearing did not go according 100% to what I had in the script. But she had someone in their ear that knows how to pivot on a dime in court. Has to pivot. That's one of the things. It's not always going to go according to the script. You got to learn how to pivot at a dime. And as soon as the numbers came up, but that was already in the arguments. That was later in the script. We brought the business records and the numbers to the forefront now. All right, ditch everything else. We're going to focus on the numbers. I'm telling you. But you can't plan. You can plan for court, but you can't. It's called the nuances of court. It's some things that you can't plan with, but you're going to have to be able to pivot. And the only thing when there's no script that you can plan for is court experience. They're going to object. And what did she bring up? The default. Oh, Your Honor, they're still in default, by the way. Come on, man. Come on. You see what I'm saying? She's running for the hills. So we got our work cut out, but I just wanted to just give you an insight because normally, you know, these social media gurus, you've had your experience. A lot of them are not really present there for people, for them, like when you're in court and being with you all of the way and making, you know, just some type of support. They just throw you a document, tell you to do your research and figure it out. But we're going to be prepared. I'm going to go over it with you and your husband. I'm going to go over our in-court game plan. So you're 100, so I can be less in your ear during court because I know you're trying to pay attention. So I can be less in your ear. And we pretty much got the game plan down pat with the pivots, just in case we got to pivot on this argument, or just in case, hey, all right, we might have to scrap that because the case is going this way. And that's one thing about court I wanted to tell you. We can have a script ready, but sometimes we have to abandon the script and kind of go with how the flow of court's going. See how we kind of abandoned the script after like the first page and we found a new angle in mid-court. These are the nuances of court. What average guru out here can prepare their clients for that? What average guru can prepare their clients to go off script? Go off script. And we're going to argue on the fly. Come on, man. Only court experience. You can do that.
You're rocking with the best.
These are the nuances of court. But you did a good job.
The documents you offered me gave me which way it could have gone.
Right.
So
right.
Thank you for that. Because the way you laid it out was like, because I was a little thrown off too, because, you know, it wasn't by my script and it wasn't that order, but the moment you said business record, I was like, all right, I remember that. And then how business record ties into personal knowledge. So yeah. Right.
There you go. So we couldn't go down the whole script because we started to get critical. So we got to go straight to a specific section. Nah, go to business record. Go to business records. Nah. So, but that was good cross. You did a very good job crossing. I forgot to tell you, that was you did a very good job. You was more composed this time. You would see that you're getting that court experience now. So you starting to get the hang of how it goes. Now
also the way you lay things out too, Lamont. Like the way you really break things down. Like I read all the documents you give me and it's like, okay, that's definitely more structured. That like you start putting pieces together. So you do help out a lot. So.
Right. Hey, listen, I wish I was your lawyer. I wish I was a licensed lawyer. I would have did all the arguing for you. They probably would have had to mute me. And that's when we get up with you, the timing of your objection. That's what I need to work on you on, the objection and the grounds for the objection. Because in court, you have to have a legal basis for an objection. So I don't want you just to be objected, then you left out of there. It can't be objected because I don't like what they saying. We got to object because of this. So I'm going to get y'all prepared for your objections. Because once you get that on top of it, I think you got the arguments down pat, like the direction, the angles. So we're attacking.
They're gonna bring up the same bullshit for next time.
I ain't telling her nothing than what the lawyers told me. The little in-betweens, the little nuances, the little being able to cite things, being able to make objectable, being able to spot what to object, being able to attack business. I ain't telling her nothing than what the lawyers told me. No, it ain't going. That's why we're gonna move for these pre-trial in-between motions, and I believe they're going to be taken more seriously this time, based on the record. The amounts due. We're gonna attack the business records. We're gonna attack the personal knowledge. But I think our biggest angle right now is the amount due. I don't think they can prove the amounts due. I don't think they have it.
Like I said, like you said, they're gonna come up with brand new numbers, and it's still gonna be questionable.
It's still gonna be.
It's gonna replay itself over again.
It's gonna play itself over again, and this time the judge.
Even if they do bring up the FHA too, I feel like they got to bring up the accounting on that too.
They got to bring. She talking about accounting now. Oh, go ahead with your bad self then.
Say like, oh, this is what this was.
Explain it. That's why I was in your ear to tell you. Make him explain it. You're just reading off the numbers. No, explain the numbers. How did you get to those numbers? And they can't do it. They can't do it. But the blueprint, the new culture is the blueprint. I'm telling you. You did a good job. I'm going to need you to get on your bulldog, be a little bulldog next proceeding. I need you to get, turn up a little bit more, because now we're going for the gusto and we're going for our own motion to dismiss. At minimum, the judge needs to at least set aside that default, at least set it aside, or dismiss their case without prejudice. The default already was on the record before I came into the picture. The default was not because of me. If she would have came to me first, there would have never been a default. We would have been at the discovery, and this probably would have been the trial. The default happened because she was with 4 gurus, and each guru had her doing things that was outside of the court rules of procedure. So the deck was already stacked against me. It was so bad that I told her to file a motion to withdraw 66, like from docket number 2 to 66. All that was the gurus. I said, remove everything from this record besides my stuff. Remove it. Withdraw it from the record. You're going to lose your home with this stuff on the record. Take it off the record. And that's what she did.
Nah, you're right too, because if there's still question about the damn records, which there is, yeah, they should be able to at least set it aside until they get their shit
get it together, set it aside. Now, don't be surprised if they file their own motion to dismiss before court. If they do. Okay, let's get into it. Don't be surprised. It doesn't mean nothing. It doesn't mean nothing. Hold on. You mean the lender mortgage company filing their own motion to dismiss without prejudice doesn't mean nothing? Nah, hell nah. That's what they use to show that they win in mortgage. No, it means nothing, because the underlying debt is not satisfied. Your motion to dismiss without prejudice means nothing in a foreclosure. Sorry to bust your bubble. Go ask a professional attorney. They'll tell you the same thing. Matter of fact, go over my lives and the videos I post. The courts are telling you the same thing. The stage, because if they filed their own motion to dismiss without prejudice, then we're going to counterclaim and file our own counterclaim as the plaintiff and them being the counter defendant. But don't, don't
back out now. Like bring it up.
Right, come back. Yeah, because the only way we can get you in the position of the quiet title, we have to get around the stuff that was done in the past. We can't. There's no way it's going to be granted now. So being transparent, giving her 100% realistic what's going on. You're not going to see us file a motion for quiet title while there's a default still on the record. No. But what do you see online every day? Defaulted borrowers filing a motion as part of their complaint, quiet title action. And they haven't even established why they're no longer legally obligated to pay the debt. See, you get reality over here. not pipe dreams, pie in the sky. You got all this money locked away somewhere. You can discharge your mortgage with the coupon. You could discharge your credit card with the coupon. Go pull up a dictionary, some epistemology dictionary with the definitions of coupon. Oh, scripts. It means script. It means money. Oh, the coupon is money now. Yeah, get the hell out of here with that BS. I got to get y'all back at least at an equal footing. Now we can start attacking their accounting from the counterplanar position. You got me? Right. Yeah. So what? Right. It's a little legal maneuvering. I just don't want to throw it out there now because I already know it's going to get denied, and then we lose that argument down the road. God damn, that's sound advice. So we're gonna keep that in our back pocket. We're gonna stay on the game plan. We're going to enhance the game plan. I'm going to go with a 15-minute recording. And now we're going to attack everything that they think they're going to bring. And we're going to move for our own motions to dismiss or set aside and give the judge the options to at least, all right, I'm going to lift it and allow them a fouler because y'all had 2 opportunities and you haven't got it done yet.
And both times I won too.
You won.
I want to add that.
Oh yeah, you won.
That was because of my emails.
Yeah, you won. Yeah, you won. Last time was because of the email we sent to him last time. This time because these are 2 victories. We pushing the accounting 2 times. We got 2 little small victories because some people got their shit taken yesterday. That's a fact. We was done. I was sitting on all the other proceedings. 3 other people lost their homes 2 days ago. 3 other people lost their homes today. I heard it with my own ears. 3 other people lost their homes.
Oh my goodness.
Yeah, a lot of people.
Oh yeah, from that trial. Yeah, a lot.
A lot of people got their shit taken yesterday. You the only one that seen they ain't get it, especially these online gurus. Now, has this experience so far been better than the ones that you had from the past with these gurus?
Yes, like you don't even understand. It's like another world. Because like I said, the fact that we even sit here and hash out like what went down, what the game plan is, or afterwards, like talk about this is what could have been done, this is what could have done, we could have done better, or this is where it could go. I've never had that with someone. No, they always just throw paperwork at me, like just figure it out, just read it, and that's it. And then, like you said, because then when it comes to court, it's not always going to go by that little scripture or by those claims that you're bringing up. It could go either way. Just like how we started asking them details about their claims, they're going to start asking us details about our claims. And the thing is, when these gurus just throw you a document, you don't know the details about it.
There you go. You didn't hear it from me. You heard it from someone who's already been around these spaces. You ain't hear from me. I'm not going to, it's unfortunate that we had to come under these circumstances, but I tell you this, you're going to see a different litigation when we get that cloud over its removed. You're going to see a totally different arguments, but it's going to be structured in a way where you can still follow. It's going to be along the same foundation, but we're actually going to attack deeper into their records. You about to see a totally different. See, the thing about the new coach empire, I can litigate from multiple different positions. You're going to see, and it's going to come up in the hearing, the motion for the hearing. I'm going to explain why they can't explain the numbers. I'm going to break down how they even got to those numbers. See, I'm going to explain why they wasn't able to justify the numbers. So I'm going to take the numbers that they're filing in court, and I'm going to transpose those numbers that's on their financial statements of position. We are talking corporate financing at its best.
You're rocking with the best.
Remember, the 5 lenses of the contract. I can argue this shit from the corporate finance lens, the regulatory lens, the investor lens, the consumer lens, and put it all under legal, valid court lens. I can hit all 4 angles from that contract and still tie it into a valid legal claim with case law to support it. That's what we're going to do. We are going to demolish their records. So keep your eyes to the streets, see what they try to file or supplement. Just any new notices. And next week, I'm gonna start getting the game plan prepared now. So by the time they do set the new hearing date, you'll be 100% ready to go.
You're rocking with the best.
They studying the source now. Supreme Elite. New Empire Talk. Came on reading numbers. They were reading memes. He was reading filings. Planning out the dream. Turn every late fee into case law heat. Judge bang.
Well, that was part 2. That was part 2 of their attempt. Now, the job is not done. The job is not done. I just got off the phone with them today again, speaking to both of them, just letting them know, it's where we're going. It's always a difficult position when you're in default in court. I don't ever want anyone to lie to you or think that, oh, just because you're in default doesn't matter. We're still going to do the damn thing. It's going to be the same as if you were the plaintiff in current. No, it is very difficult when you're in default. And when you have 4 other different peoples and their ideologies and beliefs on top of the record as well, I spent more time cleaning up these social media gurus' messes than to really getting into the things that I really wanted to get into in assisting. I just started getting into the things that I want to move because, at the hearing and court arguments. But I tell you this, we had a detailed script, right? I'm not gonna lie. I had a detailed script for her to go by, but we abandoned that script mid-trial. And this is where instincts and being attentive and attacking everything that they're saying comes into play. We literally freestyled the rest of it, sitting there taking notes. I don't send my clients documents or the people I'm assisting. I don't think it's a good strategy to send them a document just to go read. I believe that if anybody is assisting someone in court, if there's a hearing, you should at least find a way to be present at the hearing with them. Be present. Be there with them. Be there to as some type of support, because that actually helps with their confidence. If a person's first instinct is to go rush to file bankruptcy, I don't believe those people are effective teachers. If a person's in foreclosure and the first thing you want to do is say file bankruptcy, absolutely not. Especially if you're filing bankruptcy for the sole purpose of the foreclosure itself. Not saying you don't have other debts, but your real intent is for the foreclosure. Everybody that seems to keep filing bankruptcy with people in foreclosures, it always seems that the stay is getting lifted and is being remanded back. Anybody that is 100% moving to bankruptcy and you don't know the ins and outs of the bankruptcy and you don't know how to file those in-between motions of bankruptcy, I know how to maneuver between bankruptcy. I know how to maneuver. I know the in-between motions of bankruptcy. Trust me, no issues there. The problem is one of these social media gurus had her file bankruptcy. She paid $2,500 to file bankruptcy. And the guru didn't even know the checklist, didn't even have her prepared for bankruptcy. They had to get tax returns filed, this, that, and things that they wasn't even prepared for. But the gurus would say file bankruptcy, but they don't even know there's a checklist. You got to have so many things in order because the courts want to make sure that you're not trying to file bankruptcy for the sole purpose of delaying a foreclosure, because that is one of the main intents for many people in these spaces when the gurus tell them to file foreclosure bankruptcy is to delay the foreclosure. We not doing that over here. We're going to battle in the arena. whether it's state court or federal court. State court or federal, we're going to battle in whatever arena that you in. You in Alaska, we're going to battle under the Alaska rules. You in California, over there, Florida, Virginia, you want to take it to federal court, we go federal court. Well, we are well-versed in state law and federal law. Well-versed in state law or federal law. Doesn't matter. Doesn't matter over here. And I'm going to post this video on YouTube, and I'm going to post it on TikTok as well, on all my platforms, because you hear talk about it, you see the documents. But I wanted to give you the in-court experience, like what really goes down in court, because you never really ever get that on here. You don't see, okay, how do they really operate in court? Because all you see is just documents, what they call receipts. But what about in court? Where's the guru at in court with their clients? Now, we know that many are not lawyers online. So the most you could do is just, be on the phone with them. But where are they at in court? How are they preparing their clients for court? See, it's one thing just to prepare documents for them. It's one thing. Do you know how much work it goes with when you take on clients? I don't think people understand. Not only do you got to have the documents 100% on point, you got to prepare them on laws and rules and procedures that is foreign to many of them. So you have to get them prepared while maximizing their strengths and trying to minimize their weaknesses. This is why I minimized the strategy where it plays more to her strengths while minimizing her weaknesses. You notice how the proceeding didn't steer in the direction where she was weak at. We put her strengths on it, and the strengths will overshadow and protect her from her weaknesses, because I played to her strengths. And this is a lot of things about the gurus. You have to be able to adjust to your client. That's why you got to be on the phone with them. You got to get to know them. You got to analyze them when you're on the phone. You got to figure out what's their strengths. What abilities do they have within them that's going to make this proceeding as smooth as possible? What do they have with them that I can tap into? That's gonna draw that confidence out of them. Because there's nothing worse than submitting a document, making an argument, or defending the document in which the person defending it doesn't really understand. When they don't understand the vision, they don't see the vision. The only thing they're doing is just reading from a script. Before I gave her that trial hearing script, and I gave her multiple different scenarios. This is why we was able to pivot and go straight to the business records. I gave her like 5 different scenarios. And from there, as soon as we seen the case going that way, we threw everything away and went straight to that one page. And then we used that one page for a foundation, and then we freestyled the rest. Because at that time, she started picking up and understanding. So before you throw a script at them, you got to get them prepared for court. They got to have an understanding of the court rules, understanding of the court procedures. This is why I give my clients, say, listen, you're going to play a big role in this too, because you're going to have to end up in court one day. Before we get to the game plan, I want you to study these rules right here. Don't do nothing else right now, but become familiar with these rules right here. Become familiar with the rules. You have to learn the rules to the game that you're playing. There's no playing the game while not knowing the rules. It doesn't work that way. And no, we're not talking about traffic court. We're not talking about criminal court. We're not talking about family court. We are talking about civil court over here. Financial transactions, mortgages, autos, credit cards, things of that nature. We're talking about that. We ain't talk about no discharge process. We ain't talk about no debt elimination. The debt elimination comes with your understanding of the system in which the debt derives from. Once again, the easiest part in my case was the debt elimination. The debt elimination, that topic was part of the settlement. It was everything else that got there. The preparation, the time and attention to the small details, the not overlooking the small details, proper interpretation, being patient, using wisdom, using discernment. Wisdom and discernment and understanding is going to take you farther than any fucking book that they be reading online. Because wisdom, discernment, and understanding makes your interpretation clear. Many people, what they're doing, and they don't realize it, they already have their own stubborn set of beliefs on how the system works or how it should work. So anything that they're going to do, they're going to line it up with how they believe it goes or should go. Recipe for disaster. Recipe for disaster. This is where you see all this extra stuff going on. No, court is not fair. You read it, you heard it yourself. The judge kept trying to answer questions for them. We wasn't flustered because she was already prepared for that. I told her the court is going to be a little prejudicial based on the status of the account. You're in default. Just prepare for that. Don't get flustered. Stay cool, stay level-headed, and stick to the business. Even if it seems like the judge is leaning to their sides, don't get flustered. Just stick to the business. We got to make sure the record is clear. We can't have no emotional shit in court. See, that's the conversations we was having before any pen and paper was, pen was put to the paper. Before I started typing on the keyboard, I was preparing her for the realities and the nuances of court first. We didn't just start, hey, you pay me, all right, start getting the documents together. No, because I have to get her prepared for court. And that's a shame with a lot of these gurus. I'm not saying all. I'm just saying for the ones I've seen, they're not preparing their clients for court. They're not preparing them for the in-court hearings. They're not preparing them for in-court trial. I'm talking about the stages of court. Anybody can be pretty decent with filing documents. What happens when your client has to step inside of a courtroom? Your motions and documents don't mean shit then. They don't mean nothing. Your in-court arguments. You can file a motion and they have a hearing on the motion. What you put in a motion, okay, that sets the tone. But depending on your in-court argument, the judge may sway the other way. You have to argue your motions. And that doesn't mean reading the motion into the record in which you've already filed. Trust me, they already seen what you filed. They already understand what you're saying. Now it's time to argue the motion. What does argue mean? You take the core elements of your cause of action and you argue it. And you present your case in front of the judge why you should be entitled to the relief that you seek. The normal case, in any normal situation, you have the lawyer for the mortgage company. You got the business records witness, the exhibits, and then you have the accountant showing up as well. Two different witnesses with the documents. In majority of the cases, that would have been good enough for the lender to win the case. But I told my client, since you're in the position that you in, we cannot make up brand new arguments. We have to respond to what's on the record when you are the defendant. When you are the plaintiff and current, you set the record. You choose the venue, you choose the merits of your claims, and you choose what the defendant has to respond to. Now, flip side, defendant, as you can see, we don't choose, we can't come with no new merits. We have to respond to exactly what their claim is because they're the ones that's prosecuting the case. Yes, and I'm not talking about in a criminal context. I'm talking about in the civil context. The plaintiff is the one who's prosecuting the case. They're the ones who's bringing the claim. And when you're in a defendant situation, you have to learn how to adequately attack the merits of their claim. Because if you don't, you are going to lose. There's no if, and, or buts about it. You are going to lose. If you don't present genuine issues of material fact, you are going to lose. You don't have to second guess it. You're going to lose. And that's going to be a harsh lesson that many people are going to have to learn. And you're either going to learn the lesson from others' mistakes, or you're going to learn the lesson with your own property. A smart man learns from his own mistakes. A wise man learns from the mistakes of others. It's not a coincidence how we specifically attacked what we attacked. Why do we attack what we attacked at this hearing? Because the court says that's how you preclude a summary judgment. That's what precludes a summary judgment. That's how you get around a summary judgment, as you can see now. What did the courts do? Oh, we're going to reset this again. Go back in front of the original judge. It's too complicated for us. We ain't giving y'all a summary judgment. Now, why didn't the judge dismiss the case there? Well, why the judge didn't dismiss the case there? Number one, the judge already admitted the records, the exhibits into the record. Number two, the bar was in default. And I mean judicial default. So they're not going to entertain a motion to dismiss the claim prior to this hearing because technically they're still in a judicial default right now. She's not even supposed to be this far right now. She ain't supposed to be this far. She's not even supposed to be this far right now. But now, as we're looking at the procedural parts of the case now, they had two attempts. They had two attempts. And standing is a jurisdictional requirement. Now, since we have two attempts, I knew we had to go through the fire with that judicial default. Had nothing to do with me. It was already on the record before I got there. Hell, it was on the record 4 months. The first initial response to the complaint came when I filed it 4 months later. And we went to the hearing May 21st. The judge was like, man, you waited way too long. You had all the opportunities. But even their lawyer, and I'm a upload that here too, when they denied the motion. I'm a transparent. Want to know why? Because I don't have that complex. I got to put on a 100% perfect image. I show the wins. I show the losses. I show the ties. I show everything in between. Want to know why? Because when you're really a teacher, everything is a teaching moment. You don't have to put on a facade. Everything is a teaching moment. A loss over here could help someone with a win that in the future. I don't have that complex. I'm not scared what anyone's going to say. I don't have that complex. Wins and losses in court are all part of the same game. No one ever wins them all. And if anyone's claiming that they do it, they're lying. I know professionals that has more experience than all the top gurus in this space combined, and one been in court way longer. And they got L's on the record. But it's not the fact that you lost, it's how you lost. If you're losing on a Rule 12b-6 motion, which is a motion to dismiss for failure to state a claim, that is indicative that you don't understand the court rules. You don't understand the procedures. You brought a meritless claim through the door. Or if you rule on a summary judgment after you respond to a complaint, it shows that you did not state a material issue, genuine fact. Oh, I'm sorry, a genuine issues of material fact. That's rules of procedure right there. So if you're losing out the gate, it only shows that you don't understand court rules of procedure. Therefore, you should not be teaching at this moment. But if you just understand the rules of procedure, at bare minimum, you should be getting at least to the next stage. If you lose that trial, final judgment, hell, you made it that far because court is decided in stages. Many people think court is, I filed my response and the judge is supposed to just dismiss it because it's me. Court doesn't work like that. It doesn't work like that. Absolutely not. But if you can make it months down the line in litigation and the ball just happens to go the other way, sometimes that's how the cookie crumbles. Remember, court's not 100% meant to be fair. It's not meant to be 100% fair, rather. And as long as you have appealable issues, and you always have to keep appeal in mind when you're filing your motions, what you're putting on the record, you always got to keep appeal on mind. This is why good lawyers, their motions actually reads like appellate briefs rather than trial court arguments and motion. It actually reads like appellate briefs. That's what a lawyer told me. Always keep appeal in mind when you're making your record. This is why when I cite cases, I cite authoritative cases. I cite case precedents. I cite cases where the appellate courts have already decided on. Why do I do that? You think I'm doing that for my client alone? Well, that's part of it. But I'm also doing it as a hint to the judge. Hint, Your Honor. The appellate court's already ruled on this persuasive authority. And no, court judges, sometimes it's not always about the statutes as well. 98% rules of procedure. And the problem that a lot of people face is that they don't understand court doctrines. They don't understand how judges have uniformly came together and view certain transactions and what must be required. And these are called court doctrines, meaning Congress didn't pass the law. The state statutes ain't passed the law. It's the collective uniformity amongst the judges, amongst all the states to rule a certain way in these certain cases. So sometimes court doctrines is more powerful than just bare case law. Case law that's referencing court doctrines, aka it's been well settled law, or numerous of courts across America have ruled this. That is the ding, ding, ding that all the judges came together and become uniform on these issues. If you align your claims that are aligned with the court doctrines and what the courts call well settled law or have consistently held, you're putting yourself in a better position to win. And these are, once again, what I call the nuances of court. And the best way to fully understand and grasp court, and I'm speaking in a civil nature, the same principles will apply to criminal, but I'm speaking in civil nature. I don't do criminal anymore. I do straight civil. The best way to really understand these things, of course, what your research game, Your interpretation game has to be spot on. But the in-court experience is another one. The in-court experience is another one. So if you're getting your ass handed to you in court, first thing you got to ask yourself, am I losing off the gate? Am I losing off a 12B6 motion? Am I losing right at the summary judgment? If the answer is yes, then you have more understanding to do. If the answer is no, then just tighten up a few loose screws, you'll get there. Because if you're effective, you understand the rules of procedure, there should be no way that the other side is moving for a motion to dismiss or moving for summary judgment right after you respond to a complaint or right after you initiate a complaint, a lawsuit. There should be no way. They know when to file for summary judgment. Now, if they wait like 6 to 8 months down the line to try to move for summary judgment after they try to slide a new document on the record, then yeah, that's bullshit. We're talking about summary judgment right after you respond or a motion to dismiss right after you file the complaint. But if you familiar with my channel and you see what the cases I go over, what are the cases that we typically going over? 98% of what you hear online every day. And what are the hearings about? The finance company's motion to dismiss. And what's the common outcome? The court's granting the motion to dismiss for failure to state a claim upon which relief can be granted. So if you don't want to hear it from me, I'm going to let the judge tell you. That's it. Then you can argue with the judge. Don't argue with me. I'm just parroting what the judge is saying. Don't argue me. Go write your judges and tell them stop ruling that way. Don't tell me I'm only looking at it from the statutory side. You're not looking at it from the private side. Don't come on my comments telling me that. You go tell the judge that. Don't tell me. It's going to fall on deaf ears. Go tell the judge that. The court's looking at the statutes. The courts are interpreting state law. The courts are referring to your state UCC code, not the general UCC that you type in Cornell law. They're not looking at that version. They're looking at the state law. As a matter of fact, that should be an indicator that they're never looking at that version. Want to know why they're not looking at that version? Because the UCC that you see today, they don't even have all the UCC codes in there. Want to know why? Because many of them have been left out. Why? Because those are the sections of each state that differ. So the ones that you see online every day are only the ones where all the states are uniform on. Hence, uniform commercial code. But each state has their own version of it. So by definition, if you're looking at the general UCC and you're looking at a particular section, your state's version may be saying something different. Or what you're looking at now, it may not be in your state. So if you're looking at the general UCC, your state law, it may not cite what your state law is saying. Your state may be a state that does theirs a little different. This is why I say the Uniform Commercial Code is statutory law, because each state has adopted it into their statutes. I mean, and once again, this is part of, this is the beginner's learning right here. This is not even, it's beginner's learning. Every lawyer in America, every judge in America knows that secured transactions under Article 9 are governed by your state UCC laws. There's no general Cornell law UCC that you can reference, because they're always going to look at your state law, even the federal court. Remember, there's no federal common law governing these transactions. And federal court, they're going to look at your state law. They're going to interpret the rights and obligations of the parties to the transaction under the state law. This is why you have something that's called supplemental jurisdiction. But nah, I don't know what I'm talking about. I don't know what I'm talking about. You go follow the pie in the sky pipe dreams. I don't know what I'm talking about. And the mere fact that people came in my comments saying I was wrong when I went to UCC, they wasn't saying that I was wrong because I was factually wrong. They were saying I was wrong because the facts don't comport to what they believe. Why do you think I crush these people on panels all the time? I know they're arguing a belief system. I know when I click on their page, it's going to be a bunch of talk posts. I know they're not putting satisfaction and liens on the wood. I know they're not putting titles on the wood legally, not no title washing scam. I know that 98% of these people are doing some form of fraud and they call that a victory. I know that. Another thing that I know is very few of them can ever show that the underlying debt has been legally eliminated. Hence, debt elimination. See, that's what I do know as well. Very few can ever show that they took care of the underlying debt. Want to know why they can't show it? Because these are why the processes exist. The processes exist to get around the fact that they don't know how to legally get around the underlying debt. Because they have the application that they sign, they have the contract promising to pay back, they already granted security interest in the property, they've already stipulated that in the event or an acceleration and they're in default, the home can be taken or they'll be sued in court, depending on whether you're in a judicial or non-judicial state. And they can't crack that code. How do I get around a legally binding contract which says that I owe this debt? I promised to pay the debt. I did not pay the debt as promised. I've already confessed judgment. I've already granted them a security interest, and I already gave them the right to take my property and sell it or get sued in court or foreclosed on if I don't make my payments on time. See, they can't answer that question, but then they can skip past all that and say, I'm the creditor. I granted them something with the note. I gave them something with the note. I granted them something on the note. So if you granted them and you're the real creditor, why are you being foreclosed on? And this is where, because of this, and you got to do that. That's all beliefs and theories. None of that's factually correct. A creditor doesn't get foreclosed on. A creditor does the foreclosing. So by own definition, I'm a true creditor. By definition, I'm a creditor. Want to know why I'm the creditor? Because I foreclosed on my finance company. I repossessed the vehicle back from them, their security interest, and then now it's free and clear over here. By definition, I'm the creditor, right? I mean, if you want to go down that road. But I've never met so many creditors that keeps getting foreclosed on. The note was valued, right? You gave them value with the note, right? You're the creditor on the note, right? They couldn't do nothing they couldn't get the money unless you signed that note, right? Right? I know that's 99% of the beliefs in this space. Let me ask yourself a question. Now, forget the question. Let me just give you straight facts. Anybody who's saying that has no clue on how mortgages are funded. Anybody who is claiming that their signature created the credit has no clue to what's really going on. They have no clue. The mere fact that they're saying that out of their mouths. And I know it's a, sticky subject because a lot of people believe that. That's the narrative. But all those people, they have no clue to what's going on. Let me just tell you this. And you're either going to, or you're going to just say, you know what? He's right. Or you're going to figure out the hard way when you make those arguments. Somebody put the money up for you. The money was already there and transferred. And bam, seller paid for the house you're buying before you signed the note. Now let's line it up with real life actions, what happens in court. So let's take my premise and say my premise is true. So under the way I see it is, regardless of the fact that, I actually know someone that works for Fannie Mae, regardless of that fact, regardless of the fact that, I do know people who actually engages in these transactions, regardless of that, let's just look at from a real life situation because you don't know the people I know. So let's look at it from everyday life. I'm saying that somebody put the money up. I'm saying that the money was already there at closing before you showed up to closing, right? I'm saying that you signing the note secures your obligation to repay back that loan because somebody put the money up for you, right? I'm saying you are the debtor under that note, okay? Now, take beliefs and theories and put it in a trash can for a second. Let's just talk real life, everyday things that you can see around you, because that's more of a reality than something that you have yet to prove. You get what I'm saying? Could we do that for a second? That's something that you have yet to prove, your beliefs and theories. Cool. Now, if a lender forecloses on the note because you didn't pay, if you just look at it on its face, a prima facie showing, just at a glance, without getting too deep into it, just at a glance, if you just look at it at a glance, wouldn't the actions by the lenders when they sue people for non-payment or being in default, wouldn't it lead to tilt to the side that maybe just that I'm right, maybe that you're really not the creditor that many people think they are if you're being foreclosed on? And no, because a creditor, once again, a creditor doesn't get foreclosed on. A creditor is the one that has the security interest. A creditor is the right that does the foreclosing. So how can you be the creditor when you're being foreclosed on? We just talking simple logic. We're not even talking pipe dreams and theoretics and semantics and the deep esoteric. We just talking regular everyday life. And the answer can't be because people don't know who they are. It can't be because they didn't change their status. Because there's been plenty of people with the L's, Bays, Washatalkalakataka tribe that's still being foreclosed on. So changing your name, changing your status doesn't mean anything in court. It doesn't mean you're outside the jurisdiction of the court. Just think about it. And let's just, another thing to ponder on. If all I got to do is sign my signature to documents, I'm creating the money that I need, then why do I have to go to a finance company in order to create the money that I need? Because if I go to the finance company, the relationship is they're the creditor, I'm the debtor. Why would I subject myself if I'm a true creditor of the United States? Why don't I just go put my signature on something and go liquidate that signature? Because that's all you need is a signature. Why don't I liquidate that signature and then go buy the home with cash? Why do I got to go through, as a creditor, why do I have to subject myself to a borrower if I'm the true creditor? And these are all just things that your logical brain is telling you, yeah, that makes sense. But your beliefs and the pride and the ego is saying, nah, it's the other way around. But if you look at around you, everyday real life, you see the scenario that I'm talking about, you see that more prevalent. You don't really see people going into court saying that I'm the creditor and they don't owe anymore. And this is the problem with these spaces. You'll have someone come on the panel talk about, well, I was able to do it. But then you got overwhelming case law that's saying different. How can you communicate that to the next person when there's overwhelming case law saying, no, that's not what it is. It's the vapor money theory. How can you communicate? How can a teacher teach that to the next person? Because now, basically what they're saying is you have to play the lottery in these spaces. You got to be one out of 100,000 where the judge, there's great. You see how further behind the 8 ball and how more difficult you're making the shit. See how difficult you're making it even more? You're making the shit even more difficult by trying to play Russian roulette with it. Listen. You really think I care that people disagree with me? I hope you don't think I care. You really think like it's getting to the point that I'm shifting towards business clients? That's the whole thing. Like I'm reluctant. I'm very selecting on who I choose to represent as consumers. I'm very selective. I don't really do that. I'm more on the business and investor side. For number one, it's more money. Number two, it's just a headache dealing with like these consumers that come from these social media theories, belief system based groups. It's very difficult with those people. But when you get out of here, you're going to go back to whatever you're doing. You're going to go back on TikTok. You're going to stroll across another mortgage defense guru. And this is what you're going to see. You're going to see a bunch of talk posts about their beliefs on how it goes. You're not going to see them in court. You're not going to see them with their clients in court. You're not going to see satisfaction of lien, evidencing that the underlying debt has been satisfied. You're not going to see none of that. What you're going to see is, yo, come get it. I got the sauce. I know what I'm doing. You're going to see email posts in which the wordings are just too convenient. The email post reads more like, when they show the emails, it reads more like an advertisement for the next webinar than it does as someone's testimonial. It's just the wordings is too convenient. They conveniently mention, oh, I got the victory from the webinar that you posted, that you held yesterday, and the new one that you got coming up at 7 o'clock tomorrow. It's just too convenient. A person with a mortgage victory by discharging their mortgage with a promissory note, with overwhelming authority, has said, no, you can't do it. See, when a person tells me, well, I was able to do it, and then I read hundreds of case law and the regulators, and then I go back to the professional, they say, what? Absolutely not. You got to pay that mortgage with cash money. That's my partner told me. Nah, you got to pay that shit with cash money. Debit, credit, debit account, bank account, cash money. That's the only thing that moves in this system. So when I hear him say, oh, I was able to do it, I just don't believe him. And let's just say that was true. They can never reciprocate that amongst anyone else. So I don't believe them when they say they got the victories that they do, because a lot of them be lying. Remember, in this space, it's more about being right than being effective, than getting the job done. Many people just want to be right. So before I go, once again, and I hate to keep sounding like a broken record, but I'm going to say it again. Where is the satisfactions of liens at? Not, oh, I got one. I'm talking about posted on the wood, on the app. Where is, whether you got a judgment in court or a settlement and the titles to your assets, property, where's that at? I've been asking since January. Where's that at? Where is the evidence of what you teach and advocate for effective in a in-court setting? Where's the recording of that? I'm still waiting. I need to get my crickets soundbite. Because as of January 23rd, 2026, I haven't seen it. I haven't seen it. I may be wrong. And I'm not talking about a certificate of title from you doing some title washing shit at the DMV. I'm talking about the underlying debt legally recognized as settled, legally recognized as you don't owe anymore. Where's the underlying debt that is being eliminated based on all these gurus teaching? Where's the underlying debt? That's what I want to see. What's the disposition on the underlying debt? That's what I don't want to see nothing else. And we're going into July. So January, what's next week will be the 23rd? What's today? Tuesday? Monday? Today's Monday. It would be almost 6 months, 5 months. And I'm saying, where's everybody else's at? Because they've been on, they the gurus, they teach, they know what they talking about. Where's everybody else's at? I mean, hey, that's not a question for me to ask, for real. It's for you to ask. Where's mine at? Where's everybody else's at? Why am I still the lone wolf almost 6 months in? Almost 6 months in my case being over with. Why am I still the lone wolf? Why am I still the only one that's at the mountaintop? I'm looking down like, ain't nobody else up here with me? Nobody else is up here with me? Where everybody else at? I see all these discharge your auto classes, all these discharge them. Where's everybody else at? I don't want to continue to be the only one up here. Where's everybody else at? Let's come on. Spark a fire. Come on, get motivated. System ain't gonna change with just one person or a few people. For as many teachers that you have online, there should be way more titles to people's properties coming back to them. That's all I'm saying. I know how difficult it is to achieve it. I'm not saying it's easy to do. I know it's very difficult. Hell, it's even difficult to get a satisfaction of lien in a non-judicial state. I know it's difficult in court with them. I know it's very difficult. I know how difficult it is. It is extremely difficult, but that's the challenge. You got to push yourself to be great. You got to push yourself to be better. It's not an obstacle. It's just a challenge. Follow your gut. Follow your instinct. Trust me, the answer is closer than what you think. Maybe you just been overlooking what's been in front of your face. Maybe you've been overlooking what's right in front of your face. Maybe the little things matter more than the big things. Maybe they give you everything you need to scalp them. Just maybe. I don't know. I don't know. I just hope many people get it. And I hope they get it before it's too late.
AVS, ice it out. I just popped me a Molly. Nigga can't even sleep. Her pussy all in my face. Nigga can't even eat. Got me clenching my jaws. Nigga can't even speak. House surrounded by hitters. Nigga can't even creep. That fuck shit for the bird. Don't give a fuck about your feelings. Liddy gonna treat the bitches like a turd. We pulling up, just get a word. A lot you niggas floating straight garbage. I'ma send you niggas by the curb. Fuck a charge in my lawyer and he showing up and looking like a nerd. Paul speaking no English. Them niggas got the phone whips. Fuck boys and real niggas will never ever coexist. Just came home and got no paperwork. Never let a man on it lit. My bitch know I got good dick. Never talk about it with her friends. We gon' do this shit like a man. Walking down out the whips. You ask a lady for a favor. That ain't my language. Yeah, you talking French. Just turn the page on the chapter. Money pals what I'm after. So what the fuck is you saying, nigga? Shit don't even matter. Bitch know that I'm the man. Jumping in my DM thinking niggas sweet. Trying to work me with the scams. I was on the plane shackled up with the lunch bag in my hand. Was on 23 and when he came by myself, hit me with them Zans. Oh man, if I'm not with my wife, then I'm with a bad bitch. All the mochas in there try doing backflips. Diamonds icy, you can skate on them hat tricks. Dirty hoes, pussy smell like a catfish. Wish you was on my team like my last bitch. Fresh feelings down the toilet, my last shit. I ain't stopping till they dip in the casket. Still dripping, but it's slow like molasses. Pop me a Molly, nigga can't even sleep. A pussy all in my face, nigga can't even eat. Got me clenching my jaws, nigga can't even speak. House surrounded by hitters, nigga can't even creep. That fuck shit for the birds. Don't give a fuck about your feelings. Liddy gonna treat the bitches like a turd. We pulling up, just get a word. A lot you niggas floating straight garbage. I'ma send you niggas by the curb. And fuck a charge in my lawyer and he showing up and looking like a nerd.
You want too much liquor, nigga can't even try. Stay on the deuce, I done dropped about 5. You I done step in the beat with my 5. You gon' run up in your head when he fly. All I know real, I ain't telling no lie. Get your shit grilled, I'm telling you, come try. Got your bitch in my crib, that shit on island. Baby, a man eating like feet folks. So you gon' take my shit, I ain't one of them guys. Grab both my dog, ain't one of them bite. Grab both my poles, ain't one of them strike. I got 2 more folks, but I ain't got no spray. Get behind a nigga, bitch like height. Swerving lane, slamming on your bitch like Mike. I ain't got shit to say, nigga, read me my right. Catch him in traffic, he sleeping.
I just bought me a Molly, nigga can't even sleep. A pussy all in my face, nigga can't even eat. Got me clutching my jaws, nigga can't even speak. House surrounded by hitters, nigga can't even creep. That fuck shit for the birds. Don't give a fuck about your feelings. Lily gonna treat the bitches like a turd. We pulling up, just get a word. I lie you niggas floating straight garbage. I'ma send you niggas by the curb. Fuck a charge in my lawyer and he showing up and looking like a nerd.
You're rocking with the best.